She cracked it off. She said, so.
Ohio's voting maps were ruled unconstitutional 7 times.
Just like with kids, career politicians won't stop breaking the rules unless we set the rules.
Issue 1 will empower citizens to draw fair maps.
Vote yes on 1.
Oh, nothing works on this acne.
Hi.
Who?
I'm a licensed dermatology provider from Curology. Answer a few questions, I'll look at your skin and prescribe you a personal
Huh? Huh? No, I'm cool. No, I'm alright.
Sorry, do we have everybody? No, we don't. Yes, we do now. Okay. No, we don't. Yeah, I know. What is the state?
Yes, Your Honor, the state will ask that you deny defendant's motion for a mistrial. The state would like to cite the court to Swims v. State, which is 307 Georgia, 651, a 2020 case, Your Honor. In that case, which was the defendant's own enumeration of error, and I'm in Division 2 of that opinion, Your Honor, Swims contends that the trial court erred in denying his motion for mistrial after his character was improperly placed into evidence during Chelsea Owens' testimony. When the state asked Owens if Swims offered any reasoning for why he wanted to escape, Owens responded, and this is what the witness said in that case, I asked Swims, why would he do that? I said, why would you want to do that? He told me because they did not honor his fast and speedy trial. He was looking at getting off on a technicality because they didn't honor that. He didn't have that for his defense. He said he was doing time. He had a lot of time in West Virginia that he wasn't never going to get out. In that case, Swim's trial counsel immediately asked to approach the bench and moved for a mistrial. The trial court judge overruled Swim's objection and denied his motion. The state resumed its direct examination of Owens, who then testified that Swims provided another possible motivation for attempting an escape, that Swims had murdered Clemson. I asked him, did y'all kill that child? And he told me, why do you want out of here so bad? So that was how the testimony continued. I'm going to skip down. A trial court's denial of a motion for mistrial based on the improper admission of bad character evidence is reviewed for abuse of discretion by examining factors and circumstances, including the nature of the statement. Slow down, reading, please. Sorry. The other evidence in the case and the action taken by the court and counsel concerning the impropriety. And they cite Smith v. State, 302 Georgia 699. A passing reference to a defendant's incarceration does not place his character in evidence. And they cite Lewis v. State, 287 Georgia 210 at Penn site 212. Furthermore, Owens' passing reference to Swim's incarceration in West Virginia for an unstated crime was an unexpected answer to the question asked by the prosecutor, who was attempting to establish that Clemson's murder was the reason Swims wanted out of jail so bad. And they see Walker v. State, 282 Georgia 703. A non-responsive answer that impacts negatively on a defendant's character does not improperly place his character in issue. After Swim's mistrial was denied, the state did not inquire further into Swim's crimes in West Virginia beyond the single confirmation that his incarceration there also served as a motive for escape. Your Honor, given what occurred in this case, Your Honor, the state's intention when I asked the question, what was the significance of that picture? The state's intention was solely to talk about the fact that Mr. Kendrick was standing on that car being that of Rayshon Bennett. His mother had identified that car yesterday during her testimony, Your Honor. So it was an inadvertent response, which was non-responsive to the state's answer, Your Honor. And given that is what occurred, Your Honor, the state would ask that you deny their motion. Furthermore, Your Honor, other factors that you look at in order to determine whether or not a mistrial should be granted is the nature of the statement, other evidence in the case, the actions taken by the court.
The what?
The actions taken by the court. Was the reference isolated and brief, and whether the jury's exposure was repeated and extensive, and was it inadvertent? Additionally, Your Honor, within the indictments, Your Honor, we did charge Mr. Kendrick as one of the overt acts in this indictment, which is Act 58, and he's also charged in this indictment in counts 63 of this indictment, Your Honor. Possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm. Your Honor, so for the purposes of having to prove that count of the indictment, we will have to enter Mr. Kendrick's certified copy of his conviction, of course, with a limiting instruction that only be used against him, Your Honor. So the fact that came out during that testimony would not be substantially more prejudicial, Your Honor, given that, one, the jury has heard this indictment, and as well as this evidence will come out, at least that he was convicted, because we have to prove that portion of the indictment, Your Honor. So we would ask that the court deny his motion. All right. And we have instructed our witness, pass that as well. Ms. Weinstein.
Thank you, Your Honor. In the Swims case cited by the state, correct me if I'm wrong, but I do not believe that was a seasoned officer that testified about the bad character. Is that correct?
I don't know if it was seasoned officer.
No, I looked. It's not.
It's an inmate, right? And I think there's a distinction between a fellow inmate and an officer with decades of experience. And it's not just I that think that. I mean, I think if you go back and look at Posey v. State, which you may have already looked at, 152 Georgia Appeals 216. There you have a case where a seasoned officer testified about bad character of a defendant. The court in that case called for, there should have been a mistrial. It says that when it's impossible for the trial court by corrective instruction to rectify the harm done by improper testimony, a mistrial must be granted. And again, the issue here is you have a seasoned officer, someone with years of experience testifying. And in Posey, there's really very instructive language from our courts where they say we reiterate here. I'm sorry, I'm talking too fast.
And too loudly.
Yeah, you know what? I'm going to tone it down. We reiterate here what we said in Boyd. It may well be argued that peace officers are not always well acquainted with our rules of evidence and that statements such as the one here are merely inadvertent. I'm going to stop the quote for a second to say something, which is, again, here we have a peace officer, here we have an investigator who is well seasoned. The quote continues, but if we refuse to reverse this judgment, then we provide no incentive to district attorneys and solicitors to counsel their witnesses, especially law enforcement officers, to avoid extraneous and inadmissible outbursts. It is high time that this court go on record as opposing without reservation such conduct by law enforcement officers. Posey is exactly on point. Posey calls for a mistrial. This officer should have known better. The state should have properly prepared the witness to not issue, to not blurt out, to not state so clearly that my client was just getting out of prison. It cannot be corrected, Your Honor.
All right. Any last words by the state? Well, actually, never mind. It's the defense's motion, so y'all don't get any last words. All right. I think I am finding that this was not intentionally elicited on the part of the state. However, I also am finding that this witness as a law enforcement officer should have known better than to make any mention of it. It is, however, significant that one of the charges against Mr. Kendrick in this indictment is that he is a convicted felon. Were it not for that, I would grant the mistrial motion. But given that the jury already knows that he's been convicted and is a convicted felon anyway, even without this testimony, I don't think that a mistrial is warranted. I am, however, going to give a curative instruction and as a sanction for this having occurred, that's the end of the testimony from this witness. There's going to be no more testimony from him. So he's done. All right. What I am proposing to say as an instruction is Defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 and should not have been mentioned. Further, this witness, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's criminal history should not be considered in connection with any of these other defendants or any of the charges against them in this case.
Your Honor.
Yes, sir.
I would also then, because we didn't have the opportunity to cross-examine, so it would be a confrontation clause, it would be reversible error. So I'm moving.
Let me ask you this. Have y'all cross-examined him the two times before? Yes. All right, so we're going to strike everything he said today.
And the notes, just like you did before, all the notes, they have to go back, give them to the court if you don't mind, put them under seal, or that's what I remember you doing, but whatever you did with them. And if they can't follow that instruction, please alert the honorable court if you don't mind.
You're right. Can we just ask that we can just stop our testimony and give them an opportunity to cross-examine him?
No. I guess you can ask, and the answer is no.
But I don't.
The answer is no. You can make a record.
Yes, Your Honor. Your Honor, I don't believe that he and my question was broad.
It's not your fault.
And I understand that, but Your Honor, the testimony that was given today, this was a one-time one-time infraction, Your Honor, and we would just ask, we can understand that if his testimony, if the state no longer can question him, we would ask that all of his testimony from today is not stricken because of one mistake. Like, this was one mistake that he made, Your Honor. We would stop our questioning of him, allow the defense to cross him on what has come out now, but all of the information that he's provided this far, he has been careful. He has not said anything today that was even remotely close to what happened here right now. I believe it was a mistake on his part. Maybe as a state, I should have instructed clearer, and I will take that responsibility, Your Honor. But given that this was one moment in time, the state is going to ask that we will stop questioning. If that's the sanction that the state has to stop questioning him, Your Honor, we will take that sanction and ask that the defense be allowed to cross him and that we be not allowed to direct him, and that's fine, but not that his entire testimony from today be struck, Your Honor, given that that was one mistake that he made very short in time, Your Honor.
All right, understood.
Do I need to respond to that, Your Honor?
You don't
Okay.
need to.
Thank you.
Yes.
I did not mention it, but also all the exhibits admitted through this gentleman need to be taken back under seal as well and disregarded by the jury, please.
Do you have another witness available?
Yes, Your Honor. We're
Okay.
trying to figure that out.
All right, go ahead and get them lined up.
Excuse me, Your Honor. I have one question. Is retired investigator Dennis going to return to the stand at some point? I'm not sure if the state had planned on that or not, or if your sanction would bar that as well.
Oh, no, he won't be returning.
Thank you, Your Honor. I just wanted that clarified.
Unless you'd like for me to have him come back and admonish him. But I'm not going to do it in front of the jury because I don't think we need to highlight it further. Okay. I kind of would like to tell him he should have known better, though. Y'all can just relay that. Okay.
Excuse me, Your Honor, and I'd like to renew my motion for mistrial prior to the next question.
All right. It is denied.
Thank you.
Okay. Do you have another witness you can put up now, or do I need to give y'all a few minutes? Okay.
Last year, Ohioans voted overwhelmingly to protect abortion rights. This year, who we elect to the state Supreme Court could decide whether to protect or restrict those rights. The ACLU Voter Education Fund does not endorse or oppose candidates but wants you to make an informed decision. Melody Stewart, Lisa Forbes, and Michael Donnelly are supported by groups that protect abortion rights. Joe Dieters, Dan Hawkins, and Megan Shanahan are backed by groups that strongly oppose abortion rights. On abortion rights, your state Supreme Court vote matters.
wait for my meat. What hot pockets? Ain't no hot pockets. I thought them was Jay's hot pockets. He ate all them hot pockets? Oh, remember he put the chicken in the air fryer with the onion. Dad, like, they don't understand.
Why is the possession of a firearm by a convicted felon, why is that already in before the jury? That wasn't bifurcated?
It was not bifurcated, Your Honor.
Did nobody ask that it be bifurcated?
This has been a long trial, and I know you're not asking about my client's charges, but my recollection is I asked for my client's charges to be bifurcated, and it was denied, is my recollection. And so,
overact as well, and that's why I'm going to check. So it's an overact, so like a felony murder.
Okay, what is the overt act? That they're convicted felons? That would be weird. I mean, there has to be some reason, but, oh, that.
87,
That's why it wasn't that.
Okay,
189.
Well, 189. Okay, that explains it. Okay, well then I guess my instruction will say as to count 63 and alleged overt act 189. Okay, where'd my instruction go? Okay, thank you. Okay, which actually then has to change my instruction as to the rest of them too. In order to be correct, my instruction would be his prior criminal history shouldn't be considered in connection with any of the other defendants except to the extent the jury finds it relevant to overt act 189, which y'all may not want said at all. You may want me to just not say anything at all about it. So what's the defense preference, everybody other than Mr. Kendrick? You know what I'm asking? Yes. So I was going to say that his prior criminal history shouldn't be considered in connection with any of the other defendants or any of the charges against them, but that's not actually true if it's an overt act. And so do you want me to just not say anything at all about the other defendants, or say it shouldn't be considered against any of them except to the extent it might be relevant to their determination of overt act 189?
But, Your Honor, I thought we discussed this. The overt act is coming in as an admission by Mr. Kendrick, which violates our confrontation clause right. That's the instruction the state was supposed to give to you when they were talking about the same thing,
right,
overt
the
act.
conviction itself.
Right.
In that.
So that would insulate us, not Mr. Kendrick, of that overt act. And that's the instruction I tried to do. I cannot formulate it, and you asked the state to do it. It goes to Mr. Ryan.
I mean, I'd love for both of you to at least come up with your best effort on it. So
it does not apply to Mr. Matthews, Miss
any of the rest
Williams,
of them,
right.
basically. But so I know. But I think, yeah.
If I may just continue speaking, that's why I believe that Mr. Ryan's jury verdict, Mr. Kendrick's conviction, Mr. Stillwell's conviction, there might be one more, the guilty pleas, Mr. Winfrey, but I've discussed that, should all be kept out of this trial. Because somebody like me, Mr. Williams is not a convicted felon. He can't cross any of these people unless they testify. And I don't believe that a limiting instruction will be fashioned. That's my belief.
And y'all are planning to prove those as to the defendant who's convicted with their convictions, but are you doing anything beyond that?
No, Your Honor, and I think that was what Ms. Love was working on as far as crafting instruction, that it only goes against the defendant whose conviction, it only goes against that defendant, not the other.
Even as an overt act, even in consideration of RICO.
And I think that is where, as I say, we've been trying to word it, and Mr. Steele and I have had brief conversation figuring out the best wording.
But do you agree that they can't, even if they find that overt act with regard to Mr. Kendrick or Mr. Stillwell, it normally would be that, you don't, if you find that any of the co-conspirators committed an overt act, which then they would have found that as to these people, if they believe the conviction, then all you need to find with regard to the rest of the co-conspirators is the rest of what's required for the RICO violation, not a separate overt act. You know what I'm saying? And so how is it not in some way considered, it's not necessarily considered against them, but it checks a box that has to be checked with regard to each defendant that somebody committed an overt act. Okay, here's somebody who committed an overt act. And so it checks that box for the what's required for RICO.
Can I ask, Your Honor, for this purpose for right now, can we do the curative instruction that they disregard what you said?
Yeah, but I mean, what do I say? Disregard it with regard to any of these other defendants or any of the charges against them? And then y'all just are going to have to prove something else or what? Because I don't want to give them the wrong instruction. I mean, and it may be that it does have to be some other overt act with regard. I don't see how it can't, how you get around confrontation clause. You know?
Yes, Your Honor. I guess my thought is if you're striking, for purposes of today, if you're striking his entire testimony, then everything he has said is.
I know, but I'm trying to tell the jurors, Mr. Kendrick's criminal history is not relevant except with regard to count 63, an overt act. Is it 189?
Yes, Your Honor.
But really, I mean, is that?
Can we?
Or you can just strike overt act 189 out of the indictment. That would be easier.
And that was our position, because there's no way, respectfully, that a highly intelligent juror like we have is going to be able to follow this gymnastic.
And I guess our thought is, since you're striking his entire testimony now, can we deal with the felony portion of the instruction later?
I mean, I'd love to, except for the fact that now's the time to do it. I'm taking their notes away, and I'm saying to them, what you heard about him having just gotten out of prison, you need to disregard except for some very limited reasons.
But since we have not put his conviction in, if you just tell them disregard everything at this point. There's no evidence before them about him being in prison right now. So my point is, if you just tell them disregard everything that they heard, there is no other evidence for them to consider right now.
So then I would say his prior criminal history has no relevance to this case. And yes, it will ultimately have relevance to count 63. And I know we don't have what the conviction is or why he was in prison yet, and they're being told to disregard it anyway. But I mean, if y'all can come up with some better wording, great. I mean, I can just say this witness, as a former law enforcement officer, should have known better than to make any mention of Mr. Kendrick having been in prison, but.
No, I don't think that part is necessary, Your Honor. Given I do think it was a mistake. Can you read your instruction again?
Yeah.
Thank you.
Defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 and overt act 189 and should not have been mentioned by this witness. Further, this witness, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's prior criminal history should not be considered in connection with any of these other defendants or any of the charges against them in this case. I'm going to strike the testimony of the witness today, disregard the testimony exhibits, I'll collect your notes, blah, blah, blah. I mean, I guess that can just do for now, and we can get into the nitty gritty of it with regard to RICO later. I just think if we can't come up with something better in the next couple of minutes, that's what I'm going to go with. Do you want me to catch you up? Okay. All right, anything?
Your Honor, I think the limiting instruction should be similar. My apologies. Your Honor, let's see. Can you hear me now?
I can hear you anyway. Can y'all hear him? Okay.
So the state's recommendation would be the similar limiting instruction that you've been giving as it relates to the other evidence or that you've given previously as it relates to the other evidence, for example, that came in today during the prior testimony about Mr. Jackson. Pretty much the same instruction with obviously you're changing the fact that there will be certain, there will be evidence related to certain defendants that they have prior convictions. You're not to attribute those convictions to any other defendant other than the ones in which it's related to in the counts of the indictment. Something of that nature.
Okay. All right. So our issue that we're struggling with is that it's an overt act in the RICO count. And it's apparently going to be proven ultimately by his conviction, which is, of course, testimonial. And how can that be considered against any other defendant? And that hadn't been sorted out yet. I'm just going to say should not be considered in connection with any of these other defendants in this case. All right, that's what I'm going to say. So let's get the jury out. Yes. Do you need to approach if I don't have the jury here yet? Yeah, okay. I'm on it. get the jury out.
When we vote, we send a message that we will be heard.
We send a message that we will be heard.
We send a message that we will be heard.
And with so much at stake,
Our fundamental right to vote
is on the line.
We can't afford to miss this chance. Vote by November 10th.
These mushrooms make you feel better. Like, a lot better. These mushrooms make you feel better by keeping you calm and helping you focus. They keep you stress-free, but sharp enough to get things done. These mushrooms help reduce bloat and improve your digestion, so you can trust your gut instead of worrying about it. These mushrooms make you feel better. They boost your energy so you can embrace the day and help ease the aches and pains so you can get up and do it again tomorrow. So to recap, these mushrooms keep you healthy and energized, help your gut feel better and sharpen your focus while remaining calm. Oh, and by the way, they taste good too. Whew. Someone should make a coffee out of this stuff. Rise. Feel better.
I am sorry for the delay. I need to give y'all an instruction. Defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 in Overt Act 189, and it should not have been mentioned by retired investigator Dennis. And further, Investigator Dennis, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's prior criminal history should not be considered in connection with any of the other defendants in this case. I'm going to strike the testimony of Investigator Dennis that was given today. You're to disregard today's testimony and the exhibits admitted through Investigator Dennis today in their entirety. We'll collect your notes from today and shred them. And if there's anybody that is not going to be able to follow those instructions, please let the court know that now by raising your hand. Everybody good?
Huh?
Okay.
Hey,
yes.
move, man.
And He's all we've heard today so far. Anyway, we are going to hear some further testimony from other witnesses. So just, I know some of y'all are trying to conserve paper, so we'll do the same thing we did before if anybody's written on both sides, but otherwise, is that what your question was going to be? Okay. All right. So just flip to a new page now, and we've got a couple more hours, and we'll just collect them at the end of the day. All right. Okay. Call your next witness.
Your Honor, state called Officer Rogers then.
What's the last name?
Rogers.
Okay, thank you.
David Rogers, DavidRodgers.
And Your Honor, for ease, this is starting of the Act 159.
Okay, thank you.
Officer Rogers, where are you employed?
City of Atlanta Police Department.
And how long have you been with the City of Atlanta Police Department?
I just entered my 14th year.
And if you can tell the jury briefly about your history with the Atlanta Police Department.
While at the Atlanta Police Department, worked patrol for a little while before moving over to the Special Operations Section. Did about 8 years there before moving over to Special Enforcement, where I did time at the Auto Crimes Unit, and my last assignment there was at Gaines before my incident.
And we're going to talk about your incident in a moment. When you were a patrol officer, what zone did you work for?
I started in Zone 6.
And did you work any other zones as a patrol officer?
No, ma'am.
Now, you said that your last assignment prior to your incident was you working in gangs.
Yes, ma'am.
What did you do while you worked in gangs?
While on Gangs, we were tasked with proactive enforcement, keeping up with wanted gang members and the apprehension of those persons, and that was about the gist of it.
And how long did you work as an officer in the gang unit?
I was only there for 8 months.
And in those 8 months while you worked as an officer in the gang unit, what, if anything, did you do differently than the investigators in the gang unit?
Typically, we were out in the streets more, certain high crime areas, presence, things of that nature.
And as an officer with the gang unit, did you have a specific zone that you worked, or did you work the entire city of Atlanta?
Citywide.
And how closely did you work with the investigators in the gang unit as an officer in the gang unit?
We worked hand in hand. If they had certain targets or subjects that they wanted apprehended, we would go out and look for them.
And was that one of the primary responsibilities as an officer to assist with the apprehension of suspects?
Yes, ma'am.
I want to direct your attention to February 7th, 2022.
Okay.
Were you working that day?
Yes, ma'am.
And what was your normal shift when you worked as an officer with the gang unit?
My normal shift was Tuesday through Saturday, 10 a.m. to 6 p.m.
And let me ask, in 2022, were you working as an officer in the gang unit?
Yes, ma'am.
When you began your shift today, were you assigned to assist in any apprehensions on that day, February 7, 2022?
At the start of that day, we didn't have any activity. We were actually waiting on fugitive to go and serve a paper that day, or serve a warrant that day. And we were made aware that the target got mobile, and that's when we were called.
And who was the target that fugitive was looking to arrest that day?
Mr. Christian Eppinger, for the charges of armed robbery and aggravated assault, I believe the case was. And how did you get involved with the apprehension of Mr. Eppinger?
Well, we were contacted by the surveillance investigator at the time, Investigator Storno, and so we made our way from Marietta Boulevard over to Cleveland Avenue. Me and my partner for the day, we staged for a little bit and briefed while we tried to gather more resources and be updated on current information of his status and whereabouts.
Okay. And you said your partner for the day, let me first ask you, was your partner in the same vehicle as you?
No, ma'am, we were in two separate cars.
Okay. And if you're in separate cars, how was it he was your partner for the day?
We typically do everything in twos, but we were the only two officers for my unit working that day.
And who was this other officer?
Officer Jay Teasley.
Teasley?
Yes, ma'am.
Teasley?
Yes, ma'am.
All right. And you said that, were you both at Marietta prior to getting the call to assist?
We were in the area. I was on Marietta Boulevard. I don't know his specific location on the west side that day, but we were over there.
And you said that once you received the call to assist, is that when you made your way over from Marietta Boulevard to Cleveland Avenue?
Yes, ma'am.
Once you got over to Cleveland Avenue, did you go directly on Cleveland Avenue or did you stay somewhere else prior to getting on Cleveland Avenue?
No, ma'am. Prior to, so we briefed, him and myself, we briefed on the side of the Interstate 75 just before Cleveland. Talked about what we were going to do and who we were looking for, what he was wearing, things of that nature. Tried to gather more resources as far as zone crime suppression units. I think I called upon the fugitive unit that day, but they were tied up doing something else.
Now, do you remember what the description was that you were given for him?
We were told black jacket, white pants. I believe it was an orange hoodie.
Tell us what happened once you got over to Cleveland Avenue.
All right. After the brief, Investigator Storno told us that he had left the gas station and was out on foot.
Just a second. If you hear an objection, if you'll just pause.
I'm sorry, I didn't hear it.
It's okay. I know it's a little bit hard to hear. Everybody needs to use their mics. Hearsay.
Yes.
Your effect on the listener.
Sustained.
Okay. Without some.
I'm sorry, overruled.
Okay.
Overruled.
Based upon what Investigator Storno said, what did you all do?
He told us he was on foot walking from the gas station into the condominium complex. At that time, we left the side of the interstate, moved in, coming down Cleveland Avenue, turned on the Steel Road, at which time I locked eyes on Mr. Evinger, pulled into the complex.
Let me stop you right here. You said the condos in which he was going to. Do you recall the name of those condos?
I don't. The address, I believe, is 2637 Old Hateville. I don't know the exact name. The Steel Road entrance. I don't think it's a specific signage at that entrance. I think the signage is on the other side.
Have you heard of Colonial Square Apartments?
Yes, ma'am.
Does that sound familiar? No.
Not at the moment.
Okay, that's fine. Is this location within Fulton County?
Yes, ma'am.
Now, you said that the address is 2637 Old Hateville Road.
Mm-hmm.
Does the apartment complex have multiple entrances?
Yes.
Okay. Is one of those entrances on Old Hateville?
Yes, ma'am.
And is the other on Steel?
Yes, ma'am.
If you can just describe for the jury, if you're on Cleveland Avenue, what are some landmarks where that apartment complex is?
Steel Road sits between now it's a Chevron and a Checkers restaurant. I think the address, well, I don't remember the exact address for the Chevron at Cleveland, but it's Steel Road sits in between the Chevron right there at Cleveland and Interstate 75 and the Checkers.
Okay. Once you got onto Cleveland Avenue, what did you do?
Turn left on the Cleveland Avenue, coming southbound from the interstate. We crossed the overpass, pulled up at Steel Road, made a left turn onto Steel Road, at which time I could see Mr. Evinger walking through the complex, at which time I made to go make contact with Mr. Evinger.
And at the time when you went to go make contact with him, were you inside of the gate at 2637 Old Hayfield Road?
Yes, ma'am. It was it's a block of homes right there at the entrance. I think I remember him being on the sidewalk.
And at that time, once you made entrance inside, do you know where your partner was?
I don't. Last I checked, he was behind me, turning off of Cleveland Ave on the Steel Road.
Okay. Once you got into the apartment complex and you see who you believe to be Mr. Eppinger, what did you do?
I tried to pull ahead of Mr. Eppinger, get out. I gave him commands, advising him that he did have paper. Also told him he had warrants. He kind of looked at me, looked past me, proceeded to walk past me. At this time, I'm traveling behind Mr. Eppinger. I go to put hands on him, start to pull on him and things of that nature. And as I'm pulling on him, trying to grab him, I kind of start to look over my shoulder, trying to locate my partner, because Mr. Eppinger at the time was non-compliant, still walking, still kind of doing what he was doing. And when my partner wasn't there at that time, I chose to transition from lethal force, downgraded to my taser. Went to go tase Mr. Eppinger, but when I went to go access my taser, I couldn't drop the hood. I didn't drop the hood, and so when I turned my body to access it with my right hand is when I started feeling these shots.
So let's kind of slow that down, okay?
Mm-hmm.
Let me ask you this. At the time and when you went to go apprehend Mr. Eppinger, did you have your body cam on?
Yes, ma'am.
And did you have dash cam in your vehicle?
Yes, ma'am.
All right. Now you said that you got out the car and you went to go and grab him. When you got out the car, did you have your gun?
Yes, ma'am. I had my gun drawn on him at first. Came out lethal force. He was known to carry weapons and things of that nature. And like I said, I go to put my hands on him because he kind of walks past me. After I told him who I was, announced my agency, let him know that he had warrants, he kept proceeding down the sidewalk. And so as I'm engaged with him, I'm kind of looking back over my shoulder for my partner, and he isn't coming, so I had to switch to another plan since I wasn't physically able to overcome him. And so at that time, I holstered my weapon and decided to switch over to my taser. I had trouble accessing my taser.
What made you decide to switch from your gun to your taser?
Just the sheer size of him. I knew I wasn't going to be able to overpower him, but at the time he didn't have anything in his hands. And so I felt it necessary to transition.
Okay. And so when you went to go transition to your taser, were you able to draw your taser out?
No, ma'am. I stumbled with my taser, with my left hand, at which time I reached over with my right. And at that point, he had flanked me and started to fire upon me.
Okay. And when you say he started to flank you, what did that happen?
So he had veered off to my right side.
Okay. And then, did you see when he drew his weapon?
I did not.
Okay. What was the first thing that you felt?
Just a warm sensation. But I knew something was wrong because when I went to re-access my weapon, I could not have use of that arm. And when I turned around to track his person, all I remember seeing was the muzzle of the gun, the white pants, the black jacket. But at that point, I was pretty much out of the fight.
And we say you were out of the fight, what do you mean?
It's even after reaching for him, I feel like I remember reaching for him with my left hand, but my body was kind of beginning to shut down, probably from the blood loss. I don't know.
Okay. And once you started feeling those, like that bullets and that impact, where did you end up? Were you on the ground? What happened?
I remember after looking at him, I remember turning away. I feel like I took a knee. I might have even laid on my face. I sat there for a minute. I gathered myself. I got on radio, let radio know I was shot. And then at that point, Investigator Johnson came over to render aid. He pulled me around the corner, and yeah.
Okay. And after that, were you taken to the hospital?
Yes, ma'am. We waited on the ambulance for a little bit, but we kind of had a talk and a discussion, and I just requested to be put in one of the UC cars, and we made our way to Grady.
And so you said you were talking. Were you alert at the time after being shot?
Yes, ma'am.
And did you eventually make it to Grady?
Yes, ma'am.
And what were the injuries that you had as a result of this shooting?
Well, I was informed that I was shot 6 times, once to the back of the head, 4 to the back of the right shoulder, and 1 to the back of the right leg.
And did you have to spend some time at Grady because of your injuries?
Yes, ma'am. I did about 7 days in the hospital.
And are you now back to work at this point?
Yes, ma'am.
Okay. Course indulgence for a moment. I'm going to show you what's been first amendment in 32B. Do you recognize the individual who was depicted in Exhibit 32V?
Yes, ma'am. Yes, ma'am. I recognize him to be Christian Eppinger.
And I'm also going to show you 18V. Do you recognize who's that in 18V?
Yes, ma'am. That profile looks similar to his.
And I want to zoom in on 18V. Are you able to see what is depicted on the side of his face?
No, ma'am. I'm not able to make that out.
Okay. All right. I have no further questions.
Any defense questions for this witness? All right.
Good afternoon, sir.
Good afternoon.
You hear me okay?
Yes, sir.
All right. If I heard you correctly, you found out, or you came to find out after the fact, after your encounter with this guy, that you were shot a total of 6 times?
Yes, sir.
Okay. You were taken to the hospital, and you were there for a period of time before you recovered?
Yes, sir.
Okay. And you are back to work at this time?
Yes, sir.
Okay. And you described the person who was on the screen, the person you encountered, the guy you encountered as a Mr. Eppinger?
Yes, sir.
All right. All right. I'm sorry that happened to you, sir. Thank you for your questions. That's all I have. Your answers. That's all I have.
Any other? All right.
You don't see that shown in this court, correct?
No, sir.
No further questions. Thank you, sir.
Anybody else?
No, thank you.
All right. Any redirect?
No redirect, Your Honor.
All right, officer, thank you for your time and you are excused. Call your next witness.
It'll be Sergeant J.C. Davis. Let me just confirm he's outside.
I don't know what the name was.
I mean,
Davis, okay.
Raise your hand and swear firm testimony you give the truth, whole truth, nothing but the truth. I do. MC.
come get these clothes.
Please spell your first and last name for post down to the mic, please.
John Davis, JOHNDAVIS.
Okay.
And where do you work?
City of Atlanta Police Department,
And how long have you been with the City of Atlanta Police Department?
26 years.
And what do you do currently for the City of Atlanta Police Department?
I manage the body cam unit.
And what do you do as the manager of the body cam unit?
What I do is to ensure that officers that are out on the streets have body cameras that are operating properly. If any issues, I address those issues by troubleshooting, replacing, and sending them back to the Exxon unit.
Okay. And if you could just tell the jurors, are all officers with the Atlanta Police Department fitted with body cam?
Absolutely, yes, ma'am.
And since when have all officers been fitted with body cam?
This is dated back, I'm estimating 2015 or so.
2015 or so. And how are the body cams kept within the regular ordinary course of Atlanta Police Department's business?
Well, body cams, like I said, are issued to each officer to do their daily duties. At the end of each duty or personal work assignment, body cameras will be docked on the Exxon docks, where any events that particular day will be uploaded into our evidence.com accounts.
And you said the Exxon dock. What is the Exxon dock?
Exxon Docs is pretty much the same company that designed the body camera unit, and that dock is a way to charge as well as upload any evidence or any incidents that's recorded.
And as far as with APD, do you have dash cam videos?
Yes, we do.
And how do dash cam videos work?
Dash cams work similarly, but it's more of a wireless base. So once you make it back to your assignment, your precinct, the signal is sent and it uploads videos that way.
And again, are the dash cams also kept in the regular and ordinary course of business at Atlanta Police Department?
That is correct. Everything's in evidence.com in the cloud.
Have you had the opportunity today to review a body cam video and a dash cam video from a shooting incident on February 7, 2022 involving Officer Rogers?
Yes, I have.
And did that appear to be, from what you viewed, a fair and accurate depiction of images contained on both his body camera video and his dash cam video?
That's correct.
Your Honor, and did there appear to be any additions or deletions?
No, ma'am.
Your Honor, this time the state would like to tender State's Exhibit 2S, permission to approach.
You may.
I'm showing you what's been marked as State's Exhibit 1SS and 2SS. Do you recognize both of those items?
Yes, I do.
And how do you recognize both of those items?
These are the discs that I watched because I signed and dated each one.
And again, at this time, Your Honor, the state would like to tender State's Exhibit 1SS and 2SS into evidence.
All right, that's Sierra.
Yes, Your Honor.
Those are admitted without objection.
All right. Permission to publish?
You may.
Excuse me, Judge. May we approach briefly, please?
Sure.
Yeah, man, come get these clothes out of the dryer.
Granger, we're for the ones who pay attention to every little detail. The ones who fuss, tinker, and sweat the small stuff. Because you know the tiniest thing can make the biggest difference when it comes to keeping business moving. We get it. We're the same way, offering access to product experts to help you quickly and easily find what you need. So whatever your industry, you know you're always getting professional grade products. Call, click Granger.com, or just stop by. Granger, for the ones who get it done.
What you need with the clothes? Yeah, I want the dryer. Huh? Huh? I didn't do it. How would you fall over the floor and hit you upside your head, man? Yeah. What you doing, man? What's wrong with you? Freaking out. Why? That man, security guard. What about Hey! That lunch, this little they were serving that burger, that one spot, I thought something with something to the burger, that colored patties. Why was it purple? Oh no, man. That's what SpongeBob was serving. We got colored crab patties.
I have to tell you guys about our Skims bras. I always found bras to be so uncomfortable and constricting. It would be the first thing I would take off when I got home. But we changed that. Our bras are designed for all-day comfort with the most innovative technology and the softest fabric to give you the best shape while feeling like you're wearing nothing at all. The search for the perfect bra is over. Skims offers a total system of bra solutions for every need and style, and Skims bras are available in over 60 sizes. Get yours now at skims.com.
To the jury room for a few minutes. I'm not quite sure what the duration is going to be, but sorry about that. And Sergeant, I'm going to have you step outside as well, and we'll let you know when we need you back. All right, can somebody pull it up? Or... And I know y'all have had to go a little bit out of order because of the unexpected issue with not finishing the day with Detective Dennis. So we just hadn't gotten to some of this yet. I'm going to say through either misunderstanding or no fault of anybody. So we'll just tackle it right now.
Judge, can I go ahead and put my objection more fully on the record?
Sure.
All right. So the objection that I made at the bench was that the contents of the body camera and the dash camera that the state intends to introduce, the contents are going to be hearsay. Understand that there is a business records exception that they are relying on. However, that does not necessarily automatically admit the hearsay that's contained within the images and the voices and so forth on both of those items. Johnson versus State is a case that I wanted to cite to the court. It's 347 Georgia Appeals 831. That's actually a case that deals with text messages. And in Division 2, I believe, of that case, 2B, there's some instructive language. If the court will give me 1 second.
Sure, and I don't think, I mean, certainly you can put it on the record. I don't think anybody disputes the proposition that a business record certification or isn't going to get around hearsay, do they? Y'all are going to have other exceptions that you rely on. Yes. I mean, you can make the record if you want, but.
And thank you. Let me add to that also that I believe there's going to be a 4-3 analysis for the contents again of that, of the body camera, the dash camera, and I'm saying it as though there's two, but I think I may have heard the prosecutor at the bench say that there are more than two. So my objection is going to be to all of those.
Let me get clarification. There's a body cam and a dash cam of this shooting incident, right? And some of it will obviously show something different. Are there more than two with regard to this incident?
Yes, Your Honor, and because you just said that, I know we talked about it because the court asked the same question during the hearing, and you actually asked whether or not we were going to play the entirety of all of the body cam, and I told the court, no, Your Honor, we were only going to play the relevant portions of the body cam video.
Right.
And the
Yeah,
surveillance video.
Yeah,
And
I didn't mean to interrupt you. I mean, I've got those notes, and we talked at the bench about that, and it was all of it together was an hour total or something. You were going to get timestamps, and you did do that. And they know that. They just hadn't set forth. They believed they had not yet set forth any objections, and were under the impression we were going to get to it at another time. I think the state was under the impression, frankly, the court was too, that because nothing else got brought up, we were good with everything. But be that as it may, we're going to litigate it now. So.
Yes, Judge. And to add to my objection, it bears noting that the officer, Officer Rogers, who just testified. Now, Mr. Eppinger, of course, is in the indictment, but he's not here. Right? He's not here on trial with us at this point. There's been testimony given by Officer Rogers detailing the incident, his account of what happened, how it happened. And so to an extent, I think just showing the body camera that presumably, let's say it's going to show the same thing that he just testified to would be cumulative. And so I'd add that to my objection as well.
All right. I'm going to overrule that objection because the officer, in fact, said, he didn't even know how many times he'd been shot. He was kind of like weak and wasn't sure what happened. So I think it'll show things that we were not able to get through the officer's testimony. But with regard to whether there are more videos than the dash cam and the body cam, I don't know that we got that answer.
Yes, Your Honor. So there's 4 videos total.
And what are they going to show?
So the body cam will pick up parts of the shooting, Officer Rogers' movement and kind of trying to apprehend.
Sure.
The dash cam, you can actually see it because you're unable to see everything on the body cam. The other is the overall surveillance video that picks up a different image because if you heard when Officer Rogers testified, he talks about Sergeant William Johnson who comes in and gives him aid. But what Sergeant Johnson also does is he sees Mr. Eppinger firing, returns fire, and then Eppinger actually turns and returns fire towards Sergeant Johnson.
And that's on surveillance video from where? Just like
so the community had surveillance video.
Okay.
So it's from the furthest entrance at the complex.
Okay.
And then the last video, Your Honor, is the apprehension of Mr. Eppinger, and that we believe is relevant because there initially, and I think this is before this court took the bench, there was cross-examination about officers and their response in certain communities, and this video shows their response to Mr. Eppinger on this particular day, given everything that happened and how they apprehended him outside of the home. He ran into someone else's house with children and with a gun. They were able to go inside and retrieve the gun that was used, and that is the final body cam video.
All right. How long? Or let's just watch them.
Okay.
I mean, or watch the parts that I'm going to need to watch. Does every one of them have hearsay or potential hearsay on them? Are they all audio too?
They're all. The dash cam, I don't think I have the dash cam has some audio, but yes.
Okay.
But minimal. The surveillance video does not have audio.
Okay. And all right. Let's just watch them. The parts you intend to play. How long are they all for total, approximately?
We think total, if 30 minutes, but I think it's probably less than that.
Okay.
Star, are you copy? I'm going over. On Steel Road?
we need this part with him driving.
6170, 6160,
Pick it up from like a second before there.
Well, it's about to occur right now.
On the ground, boy. On the ground. On the ground. On the ground. Get on the ground. Get on the ground, bro. Get on the ground. You got paper. Get on the ground. I ain't did nothing.
And you're right. The reason why the first part is important is because that is the Cleveland Avenue area, and so that the jury can see.
Okay.
That
All right. Any objection to that? Stopping at 1917?
Yes, I'm going to object because looking at the video doesn't show the shots, doesn't show the shooting. It truly doesn't show anything that the officer testified to, and so I would say that what we're looking at is not relevant.
Okay. Overruled. All right. Move on to the next video, please.
Add 403 objection to that, please, Your Honor.
Overruled.
Hunter?
Yes.
I'm gonna, if the court allows me, I think when we watch all of these videos, they may become cumulative as well. So.
They might. That's why I'm watching them all.
Right. And so I don't want to just say I don't have any objection. I believe this is going to be cumulative to other videos that we're about to watch.
All right. Possibly. Ready for the next one? Okay. Maybe, so we don't have all the pauses when the jury's out here. I don't know, if y'all all got laptops. Maybe one person could have the next one queued up. The internet never works here. Okay.
Unless they want to get us a direct connection, that would probably make it all faster.
If we can do something like that and it would speed things up, I'll look into it. Laura, can you look into that? Yeah, no, that's fine. Go ahead. Ms. Persfield's going to go collect the jury notes from the investigator Dennis while we're doing this.
Document on an easel pad or a pad on an easel, if that could be removed as well.
That, y'all collected the exhibits already, right? Yeah, we already have all of those. So I guess that needs to get put with, I don't know which part of it was, but that needs to get put with the other evidence that was provided to Ms. Winfrey so she can have it all together. Okay, thanks. Okay, that works. I don't see you in the waiting room. I should, but. There you are. Okay.
On the ground, what? On the ground! On the ground! Get on the ground!
So that shows.
Talking to the mic.
Sorry, that shows part of the actual shooting around, which would be different than what's seen on the body cam.
All right, that's certainly different. And there's no, okay, any objection to that? And I realize I'll watch all four of them and determine the cumulative objection, but.
Same objection.
Okay. So, I don't know about cumulativeness between that and some other one yet, but it's not cumulative, it's between the body cam and that. All right, let's watch the surveillance video.
This is the first video, which is the gate. And we'll be starting at timestamp 103.
All right, hang on just a sec. Okay. Go ahead.
And we will conclude at 2:05.
And what is that showing?
So that shows Mr. Eppinger walking into the complex. So what happens immediately before? And then the two cars, so what's more important, the second car is Sergeant William Johnson's vehicle that followed behind Officer Rogers' vehicle. So what happens is Officer Rogers goes in to apprehend him, and then Sergeant William Johnson and he'll testify that he was coming from a different location, came in right behind.
Yeah.
So he's able to actually fire back at Mr. Eppinger.
Are we going to hear from Officer Johnson?
Sergeant William Johnson, yes, you
Or
are.
Sergeant Johnson?
Yes, Your Honor.
Can't he just say, and I followed right behind him in a second car?
He can. This was just
Okay,
evidence
we don't
of
need
that.
this video. All right, show me the apprehension.
No, there's one more surveillance video, Your Honor. This
Oh,
is the,
so there are 5 videos then.
Yes, Your Honor.
Okay.
This is surveillance. And Your Honor, this will just start at the beginning. And you're looking at the furthest portion of the screen.
Okay.
I have to start over because, all right. If you look towards the back of the video.
Yeah. All right, so that shows the other officer's location and interaction
Yes,
with
Your Honor.
Eppinger.
Yes, Your Honor.
Any objections on that? And there's no sound, right?
No sound on this, Your Honor.
All right, that one's in it without objection, and then, well, it will be, and then the apprehension.
Huh?
This will be the longest of the videos.
Alright, meeting to the units. There are 3 patrol cars going down the left driveway to the northwest side. So we have 20 units on that side in SWAT. You guys just let me know if you want to
Inside this apartment, how many you got?
I'm
gonna swing across. She covered that window, okay? I'm gonna stay right here, alright? Hey.
Black
Step out. Yeah. Step out. Get hurt. Get hurt. Don't get hurt.
Y'all come on.
Is anybody else in here?
I'm gonna take a spot, bro. I'm gonna take a spot, all right? All right, ready? Move.
Come downstairs. Anybody in the apartment, come downstairs. Come on, y'all.
Come on, come on.
Come on.
Come on, come on, come on, come on. Come on. Hey, come on, grab him, grab him. Don't look behind you. I'm north to south. Focus on top. Cover this window for me, man. I'm wide open. I got it. Straight to the back. Right hand side. And we need to know what door. We're on the back.
They said he went out?
Tell them 6-7. Right hand side. In the back on the right hand side. Christian.
What's his name?
Christian Aperture.
McKessie.
I got it. Christian. Hey, Christian. I know you hear me, bro. Yeah, first mile, apartment 17. Christian Aperture. If you hear me, say something.
Man, switch places. Switch out one more. Switch up here.
Christian Aperture. If you hear me, say something.
Looking at the building from the front. All right apartment. Is that correct?
Up here. I want you up here on point. You ready?
Christian Aperture.
Copy that. We have an officer on the back corner. We got one more with him.
If you hear me,
I want you up here on point.
show me your hands and come out your hands in the air, sir.
All hands go. How do we get this house from the back side?
Stop saying it. Christian, I know you hear my voice.
Sherrod Brown voted for the most conservative immigration bill in decades, and Sherrod worked with Republicans to write the law cracking down on the flow of fentanyl. But Bernie Moreno opposed the bipartisan border bill so he could play politics. Sherrod Brown fights for Ohio. Bernie Moreno's out for himself.
It's totally cool to rent a car, a house, or even this. So why not rent the stuff you need for your home?
Christian! Come out! All right, let me see your hands.
Hands first.
Crawl. 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 No, sir. Crawl. Get on your belly. Shut up. Shut up. Shut up, Harry. Get on your belly. Get on your belly. Get on your belly. Get on your belly.
On your belly.
On your belly.
On your belly.
On your belly. Crawl backwards. Crawl backwards.
6-7, 6-7.
Hey, crawl backwards, Christian. Christian, crawl backwards. Come, hey, come. We don't want to shoot you. Listen to me. I want you to crawl backwards.
On your belly.
Take the rope.
Get on your belly.
Get on your belly.
You got one more time. You're going to take the crawl.
Step out here. We don't want to kill you. Step out.
Step out.
Step out, Christian. Nobody wants to shoot you, son. Listen, Christian. Hold on, guys. Look at me, son. Look at me. Step out here. Just crawl out here.
Let me call my mama.
Christian. All right, y'all feel comfortable? Yeah. Okay. Who's taking stairs?
I'll take hands.
You got stairs?
I go.
Go.
Call my mama. I got it. Let me get right here. Ain't nobody in there.
And why is that relevant?
Previously, there was cross-examination of how officers treat individuals in this particular neighborhood and community, and this shows a complete opposite of that type of inference that officers are harass individuals in that community. Given what happened on this day where Mr. Eppercher's alleged to have shot a cop, these officers were tried to get him out in a way that was keep him alive, keep him safe, and that's a complete contradiction to some of the inferences of how officers respond in this community. So that was the
Can you be a little more specific about what kind of inferences and with what witness?
So this was early, probably around November, December. There was a line of
Okay,
cross-examination.
well, your trial didn't start with testimony until January.
No, it started in November, Your Honor. Our testimony we started opening statements in November.
Oh, Lord, it's even longer than I thought. Okay, go ahead.
Yes, Your
Sorry,
Honor.
my bad.
That's okay. So there were officers that initially we talked about a lot of drug cases that were happening in this neighborhood, and there were cross-examination about the fact that officers solely focus on this black community. Essentially that no one, they primarily harass in this community. I can't remember. I remember there were certain officers that were questioned with that line of question. I believe even maybe Investigator McKessie may have been questioned in that manner because he